Today let's talk about the obligations of depositary under Article 1981 to 1986 of Law on Credit Transactions. Article 1981. When the thing deposited is delivered closed and sealed, the depositary must return it in the same condition, and he shall be liable for damages should the seal or a lock be broken through his fault. Fault on the part of the depositary is presumed unless there is proof to the contrary. As regards the value of the thing deposited, the statement of the depositor shall be accepted, when the forcible opening is imputable to the depositary, should there be no proof to the contrary. However, the courts may pass upon the credibility of the depositor with respect to the value claimed by him. When the seal or lock is broken, with or without the depositary's fault, he shall keep the secret of the deposit. So what are the obligations of depositary when the thing deposited is sealed and closed according to Article 1981? First, return the thing deposited when delivered closed and sealed in the same condition. Second, pay for damages should the seal or a lock be broken through his fault, which is presumed, unless proven. Third, keep the secret through of the deposit when the seal or a lock is broken, with or without his fault. Example: Jess deposited a locked bag with Grace without giving her the key. At 9 p.m. in the night, a strange odor so foul started to emanate from the bag, giving Grace a difficult time to study. Can Grace open it? Of course no. If Grace does not have the key and she is not authorized, she cannot do it. If Grace returns the bag to Jess and the bag is unsealed through her fault, and the latter sues the former, will the court grant Jess damages? Yes. Grace should pay for damages since the seal or lock is broken through her fault. What if through no fault of Grace, the bag magically opens, but there is no damage? Inside are documents showing that Jess has multiple families. What is Grace's obligation under the Civil Code? When the seal or lock is broken, without Grace's fault, she shall keep the secret of the deposit. Article 1982. When it becomes necessary to open a locked box or receptacle, the depositary is presumed authorized to do so, if the key has been delivered to him, or when the instructions of the depositor as regards the deposit cannot be executed without opening the box or receptacle. So when depositary justified in opening closed and sealed subject matter. First, the depositary is presumed authorized to do so if the key has been delivered to him. Second, when the instructions of the depositor as regards the deposit cannot be executed without opening the box or receptacle. Article 1983. The thing deposited shall be returned with all its products, accessories, and accessions. Should the deposit consist of money, the provisions relative to agents in Article 1896 shall be applied to the depositary. So what is the obligation to return products, accessories, and accessions? The depositary must return the thing deposited with all its products, accessories, which is anything that is necessary for the perfection, use, and preservation of a thing, and accessions, which is anything attached to the principal thing either naturally or artificially. Note: when a depositor deposited money, the depositary cannot make use thereof, so he cannot be charged of interest. However, if she uses it without authority, she shall be liable for interest as indemnity from the date on which she did so. Article 1984. The depositary cannot demand that the depositor prove his ownership of the thing deposited. Nevertheless, should he discover that the thing has been stolen and who its true owner is, he must advise the latter of the deposit. If the owner, in spite of such information, does not claim it within the period of 1 month, the depositary shall be relieved of all responsibility by returning the thing deposited to the depositor. If the depositary has reasonable grounds to believe that the thing has not been lawfully acquired by the depositor, the former may return the same. Under this article, the proof of ownership is not necessary. The rule is that depositary cannot require the depositor to prove his ownership of the thing deposited. Depositor need not be the owner, unlike in pledge or mortgage. However, if the depositary discovers that the thing has been stolen and who its true owner is, he must advise the owner of the deposit. But if the owner has been informed and he does not claim with 1 month, the depositary is justified by returning the thing to the depositor. Example: on June 1, 2010, King deposited a watch with Marion. On June 15, Marion found out that Rhoda actually owned it. On July 1, Marion notified Rhoda. If Rhoda does not claim within 30 days, then Marion is justified in returning the watch to King. Article 1985. When there are 2 or more depositors, if they are not solidary, and the thing admits of division, each one cannot demand more than his share. When there is solidarity or the thing does not admit of division, the provisions of Articles 1212 and 1214 shall govern. However, if there is a stipulation that the thing should be returned to one of the depositors, the depositary shall return it only to the person designated. So, what is the obligation to return to the person to whom return must be made? If the thing is divisible and depositors are not solidary, each depositor can demand only his share proportionate to the deposit. For example, if Ken and Jose deposited 150 and 300 kavans of rice, respectively, Ken can only demand 150 kavans. Next, if the thing is indivisible and depositors are solidary, each of the solidary depositors may do whatever may be useful to the other, but not anything which may be prejudicial to the latter. The depositary may also return the thing to any of the solidary depositors unless a demand, judicial or extrajudicial, is made by one of them, in which case delivery should be made to him. Last Article 1986. If the depositor should lose his capacity to contract after having made the deposit, the thing cannot be returned except to the persons who may have the administration of his property and rights. The depositary is obliged to return the thing deposited when required to the depositor, to his heirs or successors, or to the person who may have been designated in the contract. But if the depositor was incapacitated at the time of making the deposit, the property must be returned to his guardian or administrator, to the person who made the deposit, or to the depositor himself should he acquire the capacity. Even if the depositor had capacity at the time of making the deposit but he subsequently loses his capacity during the deposit, the thing must be returned to his legal representative. Example: what happens if Joshua deposits a bike with Ezekiel and goes to jail because Joshua has a final judgment against him for murder? The time to return the bicycle has fallen due. To whom she should return the bike? Since Joshua would be incapacitated, the bike would go to the administrator of his estate. Again, this is Jaren Basilan and thank you for listening. Stay hydrated. Pray on.